is that the very purpose this law, and I read that judgments, that it affects the separation of doctrine of separation of powers. My lord, this court has the exclusive jurisdiction.
ये point आप repeat करते रह रहे हैं. अगला point
and that's why if any law which is made in violation of that cannot be, that affects the fundamental rights of the people of Pakistan and access to justice.
Next point.
184 की जो power, that's the original power of this court. There's appellate power is 185, sir. Advisory power is 186. Review power is 188. These are the four powers which are given by the Constitution.
No, you are wrong. There are other powers also.
I'm talking about these are the appellate men की बात कर रहा हूँ, चार powers की जो दी हुई है. Now, the original framing में appeal का right नहीं था. Appeal is only provided under Article 185. Now, if you want to give an appeal, my humble submission is that you have to amend the Constitution. And why? Because section आप पढ़ेंगे sir. आर्टिकल 175, 142 देखा, अब एंट्री 55 देख लें सर. व्हाट डज एंट्री 55
पढ़े
जी माय लॉर्ड. 175(2) आर्टिकल 142A एंड एंट्री 55 हैव टू बी रेड टुगेदर, नॉट इन
पढ़ने. 55 से कहां से शुरू करना चाहते हैं?
Jurisdiction powers all courts except the Supreme Court with respect to any of the matters list and to such. Now I'm coming and emphasizing this last part, sir, the second part of this entry. And to such extent as expressly authorized by or under the Constitution. Now, these are very important words, and my lord, I'll keep that my lord's thing. And by or under the Constitution, the enlargement of the jurisdiction Supreme Court and conferring thereon of supplemental powers, sir. The point is that the thing, पिछले जो आपके जो लिस्ट थी, उसके अंदर ये वर्ड्स नहीं थे. In the 56 Constitution, 62 and 72, expressly authorized by.
पढ़ लिए. अब आप argument develop करें.
Argument is that when you read all these provisions together, no court shall have jurisdiction except provided by Constitution or law. The 142 जो Parliament can make laws in regard for. यहाँ इंक्रीज की जो बात हो रही है, उस पे मैं सिर्फ एक पैराग्राफ जजमेंट.
इसके पावर इंक्रीज हो रहे हैं
ऑन द सुप्रीम कोर्ट की पावर. यहाँ आप
इसमें आप कह रहे हैं ये इंडिपेंडेंस जुडिशरी खत्म हो रही है क्योंकि पावर इंक्रीज हो रहे हैं.
सर, इट इज द मेथड, द मेथडोलॉजी.
वो मेथड वाला आर्गुमेंट खत्म हो गया.
नहीं सर, इसमें यही है
कि आप
आपकी ओरिजिनल जुरिस्डिक्शन के अंदर अपील नहीं प्रोवाइडेड थी इन द ओरिजिनल फ्रेमर्स ऑफ द कॉन्स्टिट्यूशन. दे डिड नॉट प्रोवाइड, ओनली द अपील वाज.
मगर मैं फिर उसका काउंटर आर्गुमेंट ये भी दे सकता हूं कि 184(3) का इस्तेमाल जिस तरीके से किया गया. नहीं, देखिए आप, सॉरी टू से, इफ समबडी albeit a person not even fully authorized is doing something to help the nation, help the Supreme Court, you should say strike down because they're not following some perceived letter of the Constitution. That will be a stretch. If this power had been given to the Federal Shariat Court, if it had been given to some secretary in the government or to the Parliament even, then you could say yes. We एक appeal दे दी. In a fit of rage, a judge says, so and so political party, I hereby ban it. खत्म. कोई solution नहीं है इसका, except review, right? You don't know, in a fit of rage, या आपकी बात किसी को पसंद नहीं आई या कुछ मिसगी हो गई, हो जाते हैं. इंसान दोनों तरफ होते हैं. तो हम यहाँ बन करके वो फरिश्ते नहीं बनते, हम इंसान ही रहते हैं. फिट ऑफ रेंज में उन्होंने कर दिया ये, तो कोई इसका सोल्यूशन ही नहीं.
मैं कहता हूँ आप बिल्कुल होनी चाहिए राइट ऑफ अपील, बिल्कुल होनी चाहिए. इट्स ओनली द मेथड, बिल्कुल होनी चाहिए.
मेथड आप मेथड विल नॉट.
आपको हमें तो हम कॉन्स्टिट्यूशन पे चल.
इट्स लाइक अ पेशेंट डाइंग ऑन द, इट्स लाइक अ पेशेंट डाइंग ऑन, सुन लीजिए, पेशेंट डाइंग समवेयर, अ पर्सन रिसीव्ड अ गन शॉट वुंड इन लाइंग समवेयर ऑन द स्ट्रीट. ठीक है. Now, someone is not a doctor but knows a little bit of medicine. He does something, tries to press him thing. Ideally, it should be performed by the doctor. So he said, no, don't do it. Wait for the water to come. Wait for him to die. And he, of course, he's not a doctor. He may be a quack, or he may just have seen some television shows, and he may just be applying some first aid, medical trade, who's not a doctor at all, not even a nurse, to save the person. So, इसमें ये बात हमें बिल्कुल इसको कर दें. इसका आप फिर शुरू में तो आप लोगों ने अटैक कर दिया था इंटेंट ऑफ पार्लियामेंट पे. तो मैं तो कह रहा हूँ इंटेंट ऑफ पार्लियामेंट इज गुड.
तो मैंने इंटेंट ऑफ पार्लियामेंट को नहीं किया.
इस साइड से लोगों ने किया है. उन्होंने कहा जी पर्सन स्पेसिफिक लॉ है, हमें बता दें पर्सन स्पेसिफिक कैसे है.
नॉट बी डिबेटेड हियर. आई नेवर सेड दैट. आई सेड कि दिस लॉ मे बी वन ऑफ द गुड लॉज. But the point is that the way it has been done is with unconstitutional. That is my case before your lordship, my humble submission. और देखिए आप बिल्कुल सही कह रहे हैं कि जी.
The question is where the Constitution has put up a scheme of separation of powers as to who can do what. there is a reason, there is a rationale, and there is a philosophy behind it which has been developed over centuries of jurisprudence. If we open the door, and this is a question of opening the door, we open the door for the Parliament to interfere in every matter that the Supreme Court may or may not take up, then there is no end to it. There would be good legislation and there would be bad legislation. How do you differentiate? The differentiation is put in the Constitution by the framers. This is what you can do and this is what you cannot do.
Yes.
Whether you want to do something good, if the Constitution prohibits you to do it, and the Constitution does not totally prohibit you. It says if there is something which should be in the Constitution is not immune from being amended to do that good.
Yes.
But to confer this power on the Parliament and say whatever you do, even if it is beyond the Constitution, if it is good, it's good. That is not how constitutions work.
Yes.
एक सेकंड है, ये ना ये जो रैशनल जो है हमारे रैशनल और रीजन और फिलॉसफी जो होती है, we tend to forget when there's trampling of boots. Then all these things, nice philosophies go out the window. The only difference between a constitutional amendment and a law, the only difference is a numbers game. Do you have 2/3 majority? It's the very same persons doing the lawmaking, the same parliamentarians who are making law. It's no difference. It's just a question of numbers. Suppose a political party comes to power on the pledge, they're going to provide 184.3. They win the election. They don't have the numbers for 2/3 majority. So they are helpless. Even though it was a pledge to the nation, we'll go, the first thing we're going to do is do this. So at the end of the day, it's a numbers game. But if it's a numbers game, then we should also realize the traumatic history of Pakistan. Irrespective of numbers, irrespective of the entire nation, one person comes and then parliament is held at whatever it is held at, and 269, 270, 270 AA, and everything is done is all right. It's a rubber stamp, done illegally, endorsed by Parliament by amendment to the Constitution. That's all right. We forgo the history of... America में ये चीजें नहीं होती. When we are so particular about the full stops and the commas, then we should also say it has not yet happened in America. It may happen tomorrow. It has not yet happened in the UK other than Cromwell. So we should not forget. We should keep in mind the history of the nation also, which is a very fragile history. It's half a country today because of these acts. So let's not cripple the parliament completely when they are doing good because they don't have the numbers 2/3 majority. That's all the argument is left with. 2/3 से कर लें, ठीक है. आपका एक वोट कम है, आप नहीं कर सकते हो. That's what it boils down to that.
Sir, my lord, to defend, protect, and preserve the constitution. If the
For the people of Pakistan.
If that is the thing, then
फिर हम आपसे वही सवाल पूछेंगे कितने लोगों ने किया है इसको.
Then constitution gives a mechanism, a procedure. You can, my lord, with utmost respect, it is not a numbers game. It is a constitution put. The framers said that if a constitutional amendment has to be made for the people of Pakistan, because they are representing where the independent judiciary will be fully secured, then you have that number games. नहीं, it is the constitutional requirement.
You were not agitated enough either to vote in to have filed your own petition. No. You have filed your own petition.
No,
or you were on notice.
Notice, sir.
So you were not agitated enough to have filed your own petition. Some people came and filed their own petition. So if you were so agitated, you should have done it the very first day yourself. The Supreme Court, it would have been very nice to see Supreme Court Bar Association.
जो cases file किए वो तो take up नहीं हो रहे जो Supreme Court
वो क्यों नहीं हो रहे take up? क्योंकि आप ये केस को खत्म ही नहीं करना चाहते.
बात नहीं है सर.
खत्म करें.
बात जी. Election petition pending.
The Constitution says we
the people of
Pakistan. Excuse me, जरा हमें भी question करने का time दिया जाए.
Give ourselves the following Constitution.
जी.
Now the people of Pakistan have said, if we want to amend the Constitution,
जी.
we would do it through our
चलिए ठीक है, ये argument हो गया, आगे बढ़ते हैं. चलें ठीक है, समझ गए 3/4 का आर्गुमेंट। चलें चल आगे बढ़ें।
मिस्टर जुबैरी,
क्या मैं सवाल कर सकती हूँ?
जी जी पूछिए जस्ट
My lord.
जी, the act says that subject to constitution and law, they have amended, they either taken the power of the Supreme Court by making rules. So what article of the constitution they have referred to? They have referred to.
They have referred.
Amendment has been made. We are opening the doors.
जी बिल्कुल सही.
In future for amending the constitution.
My humble submission is Article 175.
Simple majority.
175(2) has been read in isolation to amend this law. Basically, an amendment has been done in the Constitution by amended by 175(2). And my humble submission is 175(2) cannot be read in isolation. It has to be read with Article 142A and NT55.
अगला पॉइंट बताइए।
Mr. Zubairi, if I may, Mr. Zubairi,
my lord,
Mr. Zubairi, may I ask you and follow up on what my learned colleague has said, that when Constitution is being amended, it is constituent power that is being exercised.
My lord.
It is a unique power, quite separate and different from the other legislative competence that is available to Parliament. So I think what my learned colleague is saying is, if we open this door of an indirect amendment to the Constitution, we are allowing
floodgate
constituent power. It is not a numbers game, if I may say so, with all due respect. It is a numbers game because it is constituent power. We are allowing constituent power to flow into a channel which the Constitution prohibits directly or indirectly. So therefore, I think the point that my learned colleague has made, that this is at most or at worst perhaps an indirect amendment of the Constitution, which is perhaps barred by the Constitution itself.
Sir, tomorrow if this law
tomorrow नहीं अभी हम यही देखते हैं।
if this law is upheld,
ये बिल्कुल
for
हम नहीं
example,
करेंगे।
then the Parliament can also decide that the junior most judges will
you cannot, we have a particular case, argue that. What happens tomorrow, I am not one who gives judgments on the basis of समाइजेस। इस पे कर लें, आप बहस खत्म कर लिया, आप वही पॉइंट बार बार दोहरा रहे हैं। जरा जल्दी खत्म कर लेना, आपका वक्त निकल जाएगा दूसरों का।
You are representing the Supreme Court Bar Association. You are not petitioner nor respondent. क्या आप ये बेहतर नहीं था कि आप आके कहते हैं कि जनाब इस एक्ट को पेश करने की जरूरत क्यों महसूस हुई? मेरे ख्याल में जरूरत इसलिए महसूस हुई कि हमने 184(3) के पावर्स कॉन्स्टिट्यूशन से हटकर इस्तेमाल किए, क्योंकि अगर आप इसकी वर्डिंग पढ़ें उसमें सिंपल बात यह है, फिर से अगर आप पढ़ लें, मैं पढ़ता हूं आपके लिए, विदाउट प्रेजुडिस टू द प्रोविजन ऑफ आर्टिकल 199, द सुप्रीम कोर्ट शैल, if it considers that a question of public importance with reference to the enforcement of any fundamental right conferred by chapter 1 of part 2 is involved. हमने जो ऑर्डर्स किए, हम तो लोगों को सजा भी देते हैं, हम लोगों को बरी भी करते हैं, चीनी की कीमत भी मालूम करते हैं, बहुत सी चीजें करते हैं। क्या ये अगर हम अपने इस डोमेन में रहें तो किसी लॉ या रूल की जरूरत पड़ेगी? मेरे ख्याल में नहीं।
सर आप सही कह रहे हैं, लेकिन मेरा ये नहीं है, ये मैं कह रहा हूँ कि जी ये आप पावर बिल्कुल आप सही कह रहे हैं, गलतियां की होंगी, लेकिन पार्लियामेंट उसे सही नहीं कर सकती इस लॉ के थ्रू। दैट इज माय केस। अगर आप करेंगे तो आप खुद करेंगे सर, ये अपने रूल्स में अमेंड करके। सर
इसका मतलब कॉन्स्टिट्यूशन से बढ़कर पावर
नहीं, आप अपने रेगुलेट करेंगे अपने रूल्स और प्रोसीजर को। गलती अगर आप कहें तो आप उसको करेक्ट करें, आप उसमें रूल्स अपने रूल्स अमेंड करें, उसमें आप
अच्छा चलें, आप इस बार यू आर रिपीटिंग योरसेल्फ। अगर हम किसी और को मौका देते हैं, यू जस्ट रिपीट। नहीं, डू वांट टू कैन इफ यू रिपीटिंग योरसेल्फ विल आस्क हियर समवन एल्स।
184(3) is original jurisdiction conferred by the constitution, and it is the original jurisdiction, and if appeal is given, that would continuation of the proceeding before the original court. This is settled.
You will have a super Supreme Court.
Any provision of the Constitution where appeal is given by simple legislative power by the Parliament, that is permissible under the law.
No, my lord, under the Constitution it is not, sir. That's my. And may I just quickly take your lordship?
How would you explain enlargement of jurisdiction?
Yes, I'm coming to that.
And conferring supplemental
yes, my lord.
powers. Because you see, to be interpreted liberally as already laid down by this court.
Number of cases, sir.